Hello and welcome to the first lecture of our 2023 Last Lecture Series. The Last Lecture Series is presented annually by the class marshals, and it is an HLS tradition in which selected faculty members impart insight, advice, and final words of wisdom as we graduate. Today, we're truly honored to have Professor Michael Klarman to kick off this year's edition. I won't take so long reading his bio, since I believe most of you already know him, and he has asked me to save as much time as possible for his lecture. If you took classes with him, you will know how precise he is with the time. I will simply say that, in addition to his many achievements and accomplishments and titles, I have heard in the hallways that he is the favorite professor of the LLM class. If another professor asks, please don't quote me on that, but as his 14th Amendment student last term, I totally support and second this idea. Today, the lecture will have two parts. The first one focusing on civil rights lawyers as heroes, and the second one focusing on the threat to American democracy. We hope you enjoyed, and with that, let's welcome Professor Clark.
Thank you for inviting me. I'm honored to be asked to give this talk. The title, Last Lecture, seems a little bit foreboding to me, as in the last lecture before Professor Klarman keeled over. So I'm going to refer to it as something else. I prefer to think of it as a talk to celebrate your hopefully impending graduation. I figure my assignment on this occasion is to say something inspiring. I think many of you know that what I consider most inspiring is Major League Baseball generally, and the Red Sox in particular, although a little bit less this year probably than most. But that seems like an unfair topic, since some of you, through no fault of your own, are Yankees fans, so I'm not going to talk about baseball or the Red Sox. I'm going to give a different talk. This is about a group of lawyers whom I find as inspiring as this year's Boston Celtics, at least until the last couple of months or so. So it's a group of African-American lawyers like Thurgood Marshall, Oliver Hill, Charles Hamilton Houston, and then women's rights lawyers, most notably Ruth Bader Ginsburg. I'm going to talk about some of the special difficulties that they faced as they were struggling to accomplish their respective areas of social reform in the United States in the mid-20th century. The talk is similar to talks I've been asked to give in the past on this same occasion, but I've added something different to the conclusion. I want to say something at the end that's intended to alarm you rather than to inspire you, and that is to talk a little bit about the current threat to American democracy. I think American democracy is more under threat than any time, certainly in my lifetime, probably the lifetime of anyone who's presently alive. I think your generation has a special role to play in trying to solve that problem, to save democracy. So first I'm going to try to inspire you a little bit, and then I'm going to issue what I suppose is a call to action. I'm going to talk for about 45 or 50 minutes. I apologize because I wish there were time for questions, but I think combining those two things I want to talk about is going to take me most of the time until we have to vacate the room. All right, so for the civil rights lawyers that I'm discussing today, people like Marshall and Ginsburg, even becoming a lawyer was a significant challenge. The Southern Jim Crow system was designed so that African Americans didn't have an opportunity to become very well educated. Not that many American law schools, as you may know, admitted women either until the 1950s. Harvard Law School, as you may know, did not admit women until 1950, when Ruth Bader Ginsburg entered the law school in 1956. She was one of 9 women in a class of over 500. At the time she matriculated, women were not allowed to live in law school dormitories. They were denied access to dining tables at the faculty club, and the law review would invite the fathers of members, but not the mothers or wives, to their annual banquet. Early in the school year, the dean invited the 9 women in the class over for dinner, and he asked them at the conclusion of whatever the pre-dinner ceremony was, drinks and maybe peanuts, he asked them, why are you at Harvard Law School taking up the space that presumably a man could put to better use. When Sandra Day O'Connor graduated from Stanford Law School in 1952, she was third in her class. She just recently rejected a marriage invitation from her former classmate and future colleague, William Rehnquist. The only job she was offered, I thought you might be interested in knowing that, the only job she was offered was as a legal secretary at a law firm. When Ruth Bader Ginsburg graduated from Columbia, she transferred after 2 years because she and her husband Marty had a small child. She was tied for first in her class at Columbia. She was a member of both the Harvard Law Review and the Columbia Law Review, but she could not get a clerkship because no judge in the New York area was prepared to hire a young woman with a baby at home. They didn't think she could necessarily live up to the responsibilities. All right, moving on to some of the special difficulties these lawyers faced in their legal practice. It's useful to start by thinking about what an ordinary lawyer has to go through in preparing a lawsuit. With regard to most lawyers and most lawsuits, client brings you a case, you investigate the facts, you do some research about the law, you try to integrate the law with the facts in order to make the best arguments you can to convince a court to rule in your favor. But things were much more difficult for Thurgood Marshall or Ruth Bader Ginsburg. One obstacle that civil rights lawyers faced in the middle of the 20th century, which ordinary lawyers don't, is the threat and reality of physical violence. These lawyers were challenging a deeply entrenched system of white supremacy, which many white Southerners were prepared to use violence to defend. Remember, it had not been very long ago that African Americans were frequently lynched in the South. There were an average of 100 lynchings a year in the 1890s, and as late as the 1930s, there were still at least 20 recorded lynchings most years. Even as late as the 1940s and 1950s, many blacks who were engaged in civil rights protests were killed for what they were doing, and many, many more were beaten or maimed. For example, war veteran Etoy Fletcher tried to register to vote in rural Mississippi in 1946, and the registrar informed him, according to a letter that Fletcher wrote to the NAACP, quote, "Negroes," which of course was not the term that the registrar used, "are not allowed to vote in Rankin County, and if you don't want to get into serious trouble, get out of this building." While waiting for a bus to carry him out of town, Fletcher was assailed by 4 whites who drove him several miles into the countryside, beat him and flogged him mercilessly, and warned him that if he ever tried to vote again, he would be killed. In Montgomery County, Georgia, an African American named D.V. Carter was organizing an NAACP branch that was mostly devoted to voter registration, and several hundred blacks registered to vote as a result of his efforts. After ignoring repeated warnings from the Ku Klux Klan to desist, Carter was severely beaten. Isaac Nixon, whom he had encouraged to register to vote, was murdered, and an all-white jury acquitted the 2 whites who had killed him of the crime. Harry Moore, who was the founder of the Florida Progressives Voter League and the chief NAACP officer in the state of Florida, he was assassinated along with his wife on Christmas Day 1951 when opponents of civil rights, maybe Klan members, bombed his home. Now, it wasn't just prospective black voters and NAACP officials who faced the risk of physical violence. Lawyers did as well. Thurgood Marshall was nearly lynched in 1946 while he was defending people who were charged in connection with a race riot in Columbia, Tennessee. And D. Alexander Luby and Arthur Shores, both of whom were NAACP lawyers in the Deep South, they had their homes bombed in the early 1960s after they brought school desegregation lawsuits. There are other ways to intimidate civil rights lawyers in the Jim Crow South. It didn't have to be physical violence. A black lawyer named Arthur Madison sued to compel registrars in Montgomery County, Alabama, to register blacks to vote in 1944 during World War II. Madison was arrested, prosecuted, convicted, and then summarily disbarred for representing clients without their authorization. What had happened is that the county sheriff had intimidated Madison's clients into withdrawing their consent to his representation. No white lawyers were willing to defend him when he was prosecuted. What happened to Madison was a serious problem for African American civil rights lawyers generally. Their work often required them to walk a fine line with regard to ethical rules that constrain the behavior of lawyers, the violation of which can result in disbarment or even criminal prosecution. Those ethical rules for lawyers were designed in a very different context with ordinary litigation in mind. For example, an individual passenger on a railroad gets injured, they bring a lawsuit, they go to a lawyer wants to sue the railroad. Organizations that are organized to litigate for social reform often don't and can't work in quite that same way. The NAACP often had to go and encourage clients to sue in court. It frequently had to financially support the litigation because the clients couldn't afford to do so, and it often needed to exercise greater control over the litigation than is conventional among lawyers bringing more ordinary lawsuits. For example, NAACP officials would go to a meeting of black teachers where they would then try to persuade them that they had a right to equal pay, for example, and convince them to bring a lawsuit. They would ask for a volunteer to become a plaintiff. Then they would have to generate an insurance fund for after that plaintiff was fired, which invariably was the case. These lawyers who participated in these sorts of meetings risked violating official rules, ethical rules about lawyers not ginning up litigation. The client's supposed to go to the lawyer, not the lawyer going to the client, as well as rules against financially supporting litigation. Clients are supposed to pay for the litigation, not the lawyers. Enforcement of these sorts of ethical constraints were a principal mechanism by which Southern states tried to shut down the NAACP in the decade after Brown versus Board of Education. Now, another problem for black civil rights lawyers was the racial prejudice of the judges and juries that they were practicing before in the South in the mid-20th century who were entirely white. Black litigants would often prefer to hire white lawyers because of the prejudice they assumed that black lawyers would confront in court. When black NAACP lawyers argued cases before the Fifth Circuit in the 1930s involving voting rights claims, they were seeking access to Democratic Party primaries, which were the only elections that mattered in the one-party South. The judges on the bench literally swiveled around in their chairs, showing the lawyers their backs as a way of expressing disrespect for them. In correspondence with the NAACP's head office, these lawyers repeatedly asked whether they thought white Southern judges would ever rule in their favor, whether it was even worth bothering showing up in court, other than the Supreme Court, which they thought maybe was their only chance in which they could prevail. Yet Supreme Court justices weren't always that receptive either. Some of you have heard me talk about Justice James McReynolds, the worst human being ever to sit on the United States Supreme Court. Justice McReynolds also swiveled around in his chair, showed his back to Charles Hamilton Houston when he was arguing an important desegregation case in the late 1930s. Now think about that. Charles Hamilton Houston was a Harvard Law School graduate. He was a protege of Felix Frankfurter. He was the dean of Howard Law School. He was a brilliant lawyer. And James McReynolds is expressing symbolically his disrespect, his disdain for this lawyer who dared to show up in the Supreme Court. Women's rights lawyers faced analogous but not identical hurdles when they were arguing sex discrimination cases, often before elderly male justices who did not always take their claims as seriously as I think we would today. In 1946, the justices confronted the question of whether federal statutes permitting federal courts to exclude women from juries in states where women were technically eligible to serve. Internal records from that case make it clear that the justices saw it as an occasion to joke with each other. The exclusion of women from juries to them was a joking matter. Justice Douglas, who wrote the opinion invalidating a criminal conviction because the exclusion of women from the jury had made it unrepresentative, sent a jocular note to Justice Frankfurter proposing this revision to his draft opinion, quote, Mr. Justice Frankfurter would eliminate all sex from juries by including only males, normalizing heterosexuality as well as not taking female jury service seriously. Not to be outdone, Frankfurter replied with a proposed addition to Douglas's opinion, quote, Mr. Justice Frankfurter, being a Victorian conservative, does not believe defendants are entitled to a sexy jury. Now, as you may know, Frankfurter and Douglas despised each other. They could barely stand to be in the same room together, but they were able to find common cause, joking about this issue of whether women should be serving equally with men on juries. 30 years later, oral advocate Ruth Bader Ginsburg had to confront similarly condescending humor from the bench as she challenged the exclusion of women from juries in Missouri. After she had concluded her oral presentation to the court, one of the justices leaned over from the bench to ask one final question, quote, you won't settle for putting Susan B. Anthony on the new dollar then? In a 1970 case from New York, a state judge told a civil plaintiff who was challenging the exclusion of women from her jury not to complain to the court because her sisters prefer, quote, television soap operas, bridge and canasta, the beauty parlor, and shopping over jury service. All right, I want to emphasize another point about the job of these path-breaking lawyers, moving on to a slightly different subject, one that I don't think is sufficiently appreciated today. We think of lawyers who go into court in pursuance of a legal claim, but in some ways the most important role of these lawyers took place outside the courtroom. Civil rights lawyers went into Southern black communities and they tried to educate people, many of whom were illiterate, that they had constitutional rights, that white people were bound to respect those rights. Black civil rights lawyers such as Marshall or Charles Hamilton Houston saw part of their role as mobilizing African Americans in the South to demand vindication of their rights, to resist an oppressive racial status quo, encourage them to believe that progressive racial change was possible at a time that it might have looked very unlikely that the world would ever change, boost their morale, and also demonstrate simply through a kind of role modeling that it was possible for African Americans to accomplish great things. Houston, who was the NAACP's chief litigator in the 1930s, saw a principal goal of the litigation campaign as, quote, arousing and strengthening the will of local communities to demand and fight for their rights. Thurgood Marshall's biographer, my recently retired colleague Mark Tushnip, wrote of Marshall being brought to town ostensibly, quote, to work on pending litigation, but actually to rally the troops. In a letter he wrote to Marshall, Houston referred to himself as, quote, not only lawyer, but evangelist and stump speaker. The NAACP recognized early on the psychological benefits of using black attorneys in its civil rights cases. Southern blacks were not accustomed to ever seeing African American people stand up to whites on a footing of equality or challenge what white people said. But a black lawyer in court could try to cross-examine a white sheriff, back them into a corner, show they were lying, for example, about whether a black criminal defendant had been coerced into confessing. These sorts of performances had enormous symbolic importance for local black communities. Here's how Thurgood Marshall described one of those appearances. This is a courtroom in a small town known as Hugo, Oklahoma. This is early in 1941, and he's defending a black defendant who was charged, probably trumped up charges, with murdering a white man and his family. Now, this African American Lyons had been beaten into confessing a fact that Marshall was trying to get across, trying to get the sheriff and his deputies to admit under cross-examination. Marshall and his co-counsel, an ACLU lawyer named Stanley Belden, had agreed that Marshall would cross-examine the police officers. Belden was a white lawyer. Marshall, of course, was African American. And according to a letter that Marshall sent back to the Home Office in New York, they had agreed on that because, quote, we figured they, meaning the law enforcement personnel, would resent being questioned by a Negro and would get angry, and this would help us. It worked perfect. They all became angry at the idea of a Negro pushing them into tight corners and making their lives so obvious. Boy, did I like that. And did the Negroes in the courtroom like that? You can't imagine what it means to those people down there who've been pushed around for years to know that there's an organization that will help them. They are really ready to do their part now. They are ready for anything. So it's important to emphasize this role that Black civil rights lawyers played. This was as important as anything they did in terms of arguing school desegregation cases in the Supreme Court. They educated African Americans about their rights. They mobilized Black communities to challenge a racial status quo, which must have seemed at times as if it was impregnable to resistance. They gave African American hopes that the extreme racial oppression they were suffering might one day be susceptible to change, and they provided concrete role models to Black audiences in the courtroom. Ruth Bader Ginsburg argued 6 landmark cases in the Supreme Court in the 1970s, winning 5 of them, which is not a bad batting average, to use one of my favorite sports metaphors, though clearly not hers. She was much more of an opera fan than a sports fan. I think most people today know far less about what Ginsburg did outside the courtroom than what she did in the Supreme Court in the 1970s. The strategy of the Women's Rights Project within the ACLU, which she helped to found in 1970, was explicitly modeled after the NAACP's litigation campaign. She was not only litigating cases, she was lobbying legislatures, she was helping to train lawyers, and she was educating people around the country about gender equality. She and the WRP, the Women's Rights Project, would offer assistance to ACLU affiliates throughout the country who were engaged in their own sex discrimination litigation. She advised them about priorities, and the Women's Rights Project served as a kind of clearinghouse for information about pending cases and about what lawyers around the country were doing by way of innovative litigation to challenge sex inequality. After her victories in Supreme Court, she would write letters to ACLU affiliates advising them about what sort of follow-up litigation they might want to pursue and also what sort of legislative lobbying remained necessary. She devoted at least as much time to educating people about sex discrimination as she did to litigating against it. When her female students at Rutgers Law School in the 1960s asked for a course about sex discrimination in the law, she spent a month in the library reading every case she could find and every law review article she could find on the topic. She later said it was not a very taxing undertaking. There wasn't much written on the subject. But she did that in order to prepare one of the nation's first courses in sex discrimination in the law. She and 2 of her colleagues then put together one of the nation's first case books on that subject, and she encouraged other schools to offer similar cases. She wrote numerous articles, law review articles, talking about changes that were going on in sex discrimination law. She maintained a steady stream of correspondence with law students, urging them to write about this issue as well. She helped to educate them by sending them copies of briefs she was working on in sex discrimination cases, and she supplied many words of encouragement, telling them what they were doing was important and trying to help them contribute to the cause. She also traveled around the country while she was raising 2 children. She testified before state legislatures in support of the Equal Rights Amendment. She spoke to ACLU branches and university audiences, again trying to educate people about sex discrimination. Social reform litigation, it's important to emphasize, is not just about winning cases in court. It's also about educating public opinion, because you're not going to win in court until you've changed public opinion. Judges are never that far in advance of where the larger community is. She was an organizer, a mobilizer, a publicist, an educator for the sex equality movement in the same way Thurgood Marshall had been a generation earlier for the civil rights movement. Now, as I was saying, social reform lawyers not only organize and mobilize protests, they also play an important role as role models. I illustrated that with that story about Thurgood Marshall a little bit earlier. Now I just want to talk about Ginsburg in that regard. In 1960, a year after she graduated from law school, there had of course never been a woman serving on the United States Supreme Court. there had only been, I know this is hard to believe, 2 or 3 female federal judges in the entire history of the United States. In the late 1940s, Harry Truman had toyed with the idea of appointing a woman to the Supreme Court. At that time, there had been one federal judge who was female. Her name was Florence Allen. She was on the Sixth Circuit. That's who he was considering. But he made the mistake of consulting with the sitting justices, and they strongly opposed to his appointing a woman because they wanted to be able to take off their ties and kick up their heels during conference, and they thought they couldn't do that with a woman female colleague. In the mid-1960s, women were about 1 or 2% of law students in the United States. They were less than 2% of the nation's law professors. Ginsburg did not have a single female professor during her 3 years of law school. It wasn't until 1970 that the American Association of Law Schools amended its charter to forbid sex discrimination at member institutions, and in 1970, women were about 10% of law school student bodies. Ginsburg appreciated the importance of female lawyers arguing gender discrimination cases, just as the NAACP had appreciated the importance of black lawyers arguing race discrimination cases in the 1930s. When she learned that the ACLU was involved in Reed versus Reed, which of course you identify from common law as the path-breaking case involving sex discrimination in the Supreme Court in 1971, she asked Melvin Wolfe, who was the litigation director, whether a woman ought not to be involved in preparing the lawsuit in the Supreme Court. In litigation that was brought by the Women's Rights Project, she later noted, quote, "Particular attention was given to encouraging participation by women lawyers who seek assistance in maintaining their skills during periods when family responsibilities prevent them from working full-time." Her leadership of the WRP and her litigation in the Supreme Court was inspirational to countless women, many of whom sent letters of gratitude to lawyer Ginsburg. She herself never failed to highlight the contribution of previous generations of feminists to her own work. In the landmark brief that she co-wrote in Reed versus Reed, she placed the names of path-breaking feminists, Dorothy Kenyon and Pauline Murray, on the title page as a kind of symbolic acknowledgement that they were standing on the shoulders of a previous generation of feminists. All right, moving on to a slightly different point. One might think that the main difficulty that these lawyers would face is coming up with a convincing legal argument, but for African American civil rights lawyers and feminist civil rights lawyers, often that was not enough. The system they were challenging was so fundamentally unjust that even a convincing legal argument was no guarantee to win in court. One of the most important cases that Oliver Hill, who was the pioneering black civil rights lawyer in Virginia, was involved with was a case known as the Martinsville 7, which arose around 1950. Even many civil rights lawyers and constitutional law experts today, I don't think, know about the Martinsville 7, but it was a famous episode in mid-century American history. 7 young African-American men were charged with raping a white woman in Martinsville, Virginia in 1949. They were prosecuted, convicted, and each of them was awarded the death sentence. Oliver Hill helped represent them for the NAACP. Their trials were actually reasonably fair given the time and the region. Unlike with many similar trials that were taking place in the South, the Martinsville 7 actually had capable lawyers. They were prosecuted in trials that lasted weeks and did not occur until months after the underlying crime was committed. The proceedings were not dominated by a mob surrounding the courthouse demanding a lynching, and they had not been beaten into confessing. This was very different from some contemporary cases that were being prosecuted in similar circumstances in the rural Deep South. For example, by comparison, Charles Trudell was a 15-year-old black kid who was charged with murdering a white man in Wilkinson County, Mississippi in 1946. He had to be transferred to a surrounding county's jail because they were worried that a mob would break into the local jailhouse and lynch him. Defense counsel in his case according to correspondence that's preserved in the NAACP papers, was, quote, skating on thin ice in the trial of this case in a courtroom packed with a vengeful community, which overflowed even into the courtyard. Trudell's lawyers were unwilling even to ask for a special jury veneer because they feared that that would produce immediate violence. The trials of the Martinsville Seven were meaningfully different. Also, it turns out there's no doubt that they were guilty as charged. There are only two problems with the proceedings in the Martinsville courthouse. All 72 jurors who sat in the 6 different criminal trials were white, and the state of Virginia never executed African Americans. Sorry, they never executed whites for the crime of rape, only African Americans who were charged with raping or attempting to rape white women. Of the 45 men executed by the state of Virginia for the crime of rape between 1908 and 1950, every single one was African American, and the only way the state could get away with that was that African Americans were still not being permitted to serve on juries. Hill and the NAACP raised that claim in court. They tried to raise it in the Supreme Court. The claim is, of course, not that the trial was unfair because there wasn't a lawyer or because of mob domination, but rather that racially disparate administration of the death penalty violates the Equal Protection Clause. It seems hard to deny that that claim is right. Indeed, it seems almost hard to believe there could be any stronger claim. That's exactly what the framers of the 14th Amendment were worried about. If the state's not executing white men for the crime of rape, then it shouldn't be allowed to execute black men either. That claim won in the Supreme Court, but as you may know, it won in 1977. The Supreme Court would not even take the case in 1951. They denied review. The Martinsville Seven were executed by the state of Virginia, the largest mass execution or lynching for the crime of rape in American history. Now, Ruth Bader Ginsburg confronted an analogous, although not identical, difficulty in convincing elderly male justices in the 1970s of the insidious consequences of sex discrimination. The problem is that virtually all sex classifications are what she liked to call a double-edged sword. Many such statutes tangibly disadvantage men, not women, and the way in which they disadvantage women are through intangible perpetuation of stereotypes of female dependency, passivity, and the lack of business acumen. Ginsburg needed to convince the justices that women were harmed. For example, you're familiar with these cases from constitutional law, young girls being allowed access to a certain form of beer at an earlier age than young males, or laws requiring that men pay alimony but women never have to, or laws saying that women are eligible for jury service but only if they volunteer, whereas men are conscripted. In a telling conversation with Harvard Law School students early in 1973, Justice Potter Stewart expressed bewilderment. Why do women want an equal rights amendment? In his view, quote, the female of the species has the best of both worlds. She can attack laws that unreasonably discriminate against her while preserving those that favor her. Ginsburg reported feeling depressed when she heard that account of Justice Stewart's talk. She understood that she needed to educate male justices into seeing that all sex classifications, even those that seem to afford tangible benefits to women, always come with a cost, the perpetuation of these harmful stereotypes. The most insidious of those stereotypes, according to her, were the stereotype of the male breadwinner and the female homemaker. A lengthy exchange between Ginsburg and several of the justices in Califano versus Goldfarb in 1956 illustrates how difficult it was to convince elderly male justices that sex classifications invidiously affected women, even if they tangibly disadvantaged men. The Social Security provision that was at issue in the Goldfarb case provided survivors' benefits to the widows of covered male employees, but they required, in the inverse situation, the widowers of covered female employees to demonstrate actual economic dependency before they could get these benefits. That meant in practice they had to show that their wives had provided 50% of their income. Now to Ginsburg, a provision like that has three clear problems with it. First of all, it discriminates against the female wage earner. Second, it discriminates against the male recipient of the survivor's benefits. And third, it perpetuates the invidious sex stereotype that men are the breadwinners and women are the homemakers. The first question directed to Ginsburg came from Justice Potter Stewart. This is, does the provision discriminate against men or does it discriminate against women? Couldn't it be cast either way? And why was Ginsburg treating it as discrimination against women? If the sexes were switched, Stewart asked, if the female beneficiaries were the ones required to establish financial dependency, would that make a constitutional difference? And her response, of course, was, quote, the line drawn here, like virtually every gender discrimination, is a two-edged sword. Now, Stewart persisted. Some recent court decisions had focused on the history of discrimination against women, but he doubted that there was any analogous history of discrimination against men. Ginsburg responded, quote, most anti-female discrimination was dressed up as discrimination favoring the woman. Stewart replied at this point impatiently, quote, I know that, but the courts through the help of advocates such as you have been able to see through that, haven't they? At that point, there was laughter in the audience. Ginsburg gamely reiterated that sex classifications inevitably harmed women. Persisting, Stewart asked her to imagine an instance of discrimination against men. Would her constitutional argument be equally strong? She replied her argument would remain unchanged, quote, because I don't know of any purely anti-male discrimination. In the end, the women are the ones who end up hurting. Now, a moment later, recently appointed Justice John Paul Stevens took up the same line of questioning. Should discrimination against males be subjected to the same standard as discrimination against females, or a different standard? Ginsburg repeated her previous answer, quote, almost every discrimination that operates against males operates against females as well. Ginsburg insisted, bewildered, now apparently growing annoyed, Stevens responded, quote, is that a yes or a no answer? I don't understand. Are you trying to avoid the question? Ginsburg insisted she was trying to clarify, not to evade. She was aware of no sex classification that did not operate as a double-edged sword. The exchange went on to similar effect for a while longer. Then from the bench comes this question. But your answer always depends on their finding some discrimination against females. You seem to put that in every answer to this question. Ginsburg, who I think pretty clearly was growing exasperated at this point, reiterated, I have not yet come across a statute that doesn't have that effect. Justice Stevens persisted. But if there were one, then you would say it would be treated under a different standard, I take it. Now, Ginsburg didn't want to alienate a potential ally. She thought that would harm her case, so she relented. She says if there was such a statute, she would reserve judgment on what the standard would be, but she repeated she had yet to come across such a statute. Now, Justice Stevens and Justice Stewart were extremely intelligent men. Their inability to comprehend what I think to most of us today would be a kind of second nature point illustrates how much lawyers are up against when they're trying to challenge a dominant ideology that makes the status quo seem just and reasonable. You can't even make people understand this basic point that discrimination that seems to favor women actually harms them. All right, so I'm going to move on to the other part of my talk. I've been asked to do this talk before and it stopped here, and I hope that I inspired you, but now I want to say something that is a little bit alarming to you. We're facing the greatest threat to democracy. I think you've heard this before. Certainly many of you have heard this from me, that any of us have faced in our lifetime. And unfortunately, the threat comes from one of our great political parties. Now, what I'm about to say may sound partisan, and this is obviously not the place to give a partisan talk, so I want to preface it with a very brief illustration of why I don't think this is actually a partisan point. There are moments in history, not that many moments, where doing the right thing, doing the just thing, actually may require doing something that has incidental benefits to one of the main political parties. Those of you who are in my constitutional history class, which is at least a few of you, will recognize the example. When Republicans enfranchised African Americans during Reconstruction through the 15th Amendment, they acted with dual motivations. They were both doing what they thought was the right thing, and they were benefiting themselves politically. Every single Democrat in Congress and just about every single Democratic state legislator in the country opposed the 15th Amendment. The Democratic Party then was the party of open white supremacy. Democrats believed that the United States was a white man's republic. They denied that African Americans were mentally or morally equipped to participate in that republic. So I want to emphasize that the 15th Amendment was enacted by a straight party line vote because the opposition political party did not believe in interracial democracy. The party that supported the 15th Amendment believed in interracial democracy. They thought that African Americans had won the right to vote through their loyal service in the Civil War, but they also appreciated, they were not oblivious to the fact that African Americans would vote overwhelmingly Republican because the Republican Party was the party that had freed them from slavery, the party that had turned them into citizens, and the party that was giving them the right to vote. All right, so it pains me to say this, partly because some of you will regard it as inappropriate partisanship, but we sometimes have to speak the truth even when it's painful. The following facts are all true about today's Republican Party. 70% of its voters do not believe that Joseph Biden is legitimate president of the United States. 60% believe that former President Donald Trump did not have classified documents at Mar-a-Lago. 60% believe that the people who assaulted the Capitol and killed some police officers on January 6th were engaged in peaceful and law-abiding activity. The Republican National Committee calls the attack on the Capitol on January 6th legitimate political discourse. According to recent polling, a majority of Republican voters want the person who incited the violence on January 6th to be their presidential candidate in 2024. Now, it is an enormous mistake to think that the problem here is primarily Donald Trump. The anti-democratic practices that have become prevalent over the last 15 or 20 years precede Trump's arrival on the political scene. Republican legislatures since about 2000, certainly 2004, have suppressed votes through voter restriction laws. They've purged the voter rolls, trying to disfranchise people of color, poor people and young people, people like yourselves, all of whom disproportionately vote Democratic. To take a recent example, only the most extreme example, when Democrats won 2 U.S. Senate seats in Georgia for the first time in decades, the Georgia legislature, controlled by Republicans, adopted the following measures, all of which target Democratic voting practices. The law makes it harder to obtain absentee ballots and to cast absentee ballots. The law drastically limits the number of drop boxes around the city of Atlanta. It expands the ability of poll watchers to challenge voters. It bans counties from establishing mobile polling places. It virtually eliminates the use of provisional ballots for voters who turn up at the wrong precincts. And it criminalizes offering food and water to people standing in line to vote. In addition, we have grotesque gerrymandering of legislative districts by Republican legislatures, enabling the party to take control of state legislatures and of the House of Representatives, even while not winning a majority of the vote. Republican state legislatures are increasingly rejecting the results of voter referenda on issues like establishing independent commissions to draw district lines. They are now imposing substantial impediments to any kind of referenda, requiring supermajorities, making it harder to get signatures, making it more difficult to register, to sign up people on the petitions. This is from a party that purports to be a populist party, but is thumbing its nose at the voters who, for example, have now demonstrated they will vote for abortion rights, even in a state like Kansas. The Variety of Democracy Institute, Varieties of Democracy Institute, which measures global democracy, assigns the world's major political parties an annual illiberalism score, which measures things like commitment to pluralism, respect for civil rights, tolerance of opposition, and willingness to reject in an unmitigated fashion any sort of political violence. Most Western European conservative parties post a perfect score. The Republican Party in the United States posted a perfect score in the 1990s. Today, the GOP's illiberalism scores are analogous to that of the Fidesz party in Hungary and Law and Justice in Poland. In 1920, VDem, which is another one of these international nonprofits that ranks democracy, treats the Republican Party as now, quote, more similar to autocratic ruling parties such as the Turkish AKP and Fidesz in Hungary than to a typical center-right governing party. How'd we get into this situation? There are 5 principal causes. I can't go into this in any great length. This is about race, this is about religion, this is about growing inequality. Let me say a quick word and then say something about what might be done. Political scientists think this is mostly about race, that this is about racial resentment. The United States in the 1950s was 90% white, 10% black. That has changed today. It's now 50% white, 44% non-white. Demographers project that the United States will no longer be a white nation by about 2040. The coloring of the nation, perhaps best exemplified by the election of a black president in 2008, has proved profoundly unsettling to many Americans. It's made them vulnerable to the appeals of a racist demagogue such as Donald Trump. As late as the 1980s, according to political scientists, Democrats and Republican voters were equally likely to register high on these polls that try to estimate racial resentment. By the 2016 Republican presidential primary, racial resentment was highly concentrated in the Republican Party, and it correlated strongly with support for Donald Trump in the primary. What do we mean by racial resentment? These are the people who tell pollsters that whites in the United States suffer more from race discrimination today than blacks, that Barack Obama, even today, they do not believe was born in the United States, and who admire President Trump when he tells black and brown congresswomen that they should go home to the shithole countries they came from, even though most of them come from the United States. Now, a potent second factor is changes in religious demographics and the decline of religiosity. It's hard to believe today, but in the 1960s, Democratic and Republican voters were essentially equal in their religiosity. If you knew somebody went to church once a week, you knew nothing about their partisan affiliation. The culture war issues of the 60s and 70s, changing views about homosexuality, changing views about the legal regulation of abortion, were starting to push religious conservatives into the Republican Party. That accelerated in the 1970s. Jerry Falwell began mobilizing evangelical Christians in the late 1970s into the Republican Party to support Ronald Reagan and his election as president in 1980. Beginning around 1990 and accelerating dramatically in the last 3 decades, religious conservatives have come increasingly to appreciate that they are losing the battles over the normalization of homosexuality, over changing sexual mores, and over the role of women in American society and politics. In recent decades, religious conservatives see their grandchildren and their children abandoning the church in record numbers. Today, and this is the most important number I can give you, roughly 2/3 of Americans who are 65 or over are white Christians, whereas among those aged 18 to 29, that number is 29%. The number of Americans claiming no religious affiliation at all has increased from 7% in the 1970s to 25% as of about 5 years today, and among your age group, 18 to 29-year-olds, it's about 40%. For the first time in American history in 2024, white Christians may not be a majority of the electorate. Those are profoundly disorienting developments for those who think of the United States as a white Christian nation, which it has been unofficially for nearly the entirety of its history. The rise of an extreme form of economic libertarianism is the third factor. Radical libertarians who do not believe in government intervention were largely marginalized during the Depression and during World War II and the couple of decades after. But beginning in the 1960s, they've made a very significant cultural and political comeback. Libertarian billionaires like the Koch brothers have invested in libertarian think tanks that were created in the 1970s, like Heritage and Cato. They asserted their influence on college campuses through the Olin Fund and in law schools through the Federalist Society. They gained political ascendancy during the presidency of Ronald Reagan, who taught us that government, this is quoting his inaugural address, government is always the problem, never the solution. This kind of renaissance among economic libertarians has culminated today in a Republican Party that mostly believes in tax cuts for the wealthy and corporations, cutting back on the social safety net, not doing anything about climate change, and deregulation. Those people have never really prized democracy because there's always a risk that a majority will redistribute wealth, and that's something that they believe needs to be resisted. As their economic policies become more radical and less popular, it's inevitable that they start to try to sow racial and religious grievances. It's the only way to win votes. The fourth factor contributing to Democratic decline is the enormous increase in economic inequality over the last 40 years. For much of American history, from 1930 to 1970, the middle class did very well. Increasingly, they saw their wages double every generation. You could buy a home, you could put your kids through college, often on a single income. That has turned beginning around 1980. 2/3 of the gains from economic growth since 1980 go to the top 10%. 1/3 of the gains go to the top 1%. American workers now have lower life expectancies than in many comparable countries around the world. Their babies have higher infant mortality rates, and they have worse access to health care. Life expectancy in the white working class, ages 45 to 65, have gone down independently of the pandemic. That's something that never happens in world history. Worsening economic inequality and the social pathologies that accompany it have created a golden opportunity for a racist, faux populist demagogue like Trump to appeal to these economically dispossessed workers. Those people ought to be blaming their ills on globalization, technological change, and the neo-Ayn Randian radical economic policies of the Republican Party, but instead they're being convinced to blame Mexicans and Muslims and Satan-worshiping child molesters in the Democratic Party. All right, I have a fifth factor, but obviously we're running out of time and many of you have class. If you want to continue living in a democracy, it's not a spectator sport. I think for most of the people in my generation, we assumed that democracy was inevitable. International political scientists told us 30 years ago, democracy is inevitable, it's going to spread around the world, and it turned out that that's not as true as we thought. Some of you are going to embark on legal careers where you're actually going to spend much of your time struggling for democracy. I can't tell you how much personally I admire what you're going to do, but I'm speaking to the rest of you right now, and that includes me. I don't pursue a career path that's mostly about preserving democracy. Everybody needs to do something. You don't need to do everything. It's great that there's some people who are committed to do everything. Everybody needs to do something. At a minimum, you need to vote. You need to get your friends to vote. You need to write postcards. You need to knock on doors. You need to phone bank. You need to act as if your contributions will make a difference, because collectively, that is something that I think is very true. Let me quote a line from Frances Perkins. Many of you have never heard of her. She was the first woman to join a president's cabinet. She was FDR's Secretary of Labor for the entire 12 years of his 4 terms in office. He died early in the 4th term. And she was a very important social reformer in the first half of the 20th century. This is what Perkins said: "There's always a large horizon. There's much to be done. It's up to you to contribute some small part to a program of human betterment for all time." She was talking about industrial reform, fair labor standards, trying to prevent accidents in industry. I'm talking about democracy. But for either project, there is a moral obligation, I think, to do something, and you can have confidence that there are tens of millions of other Americans who are trying to do their small part as well. So thank you for giving me the opportunity to talk to you, maybe preach at you a little bit. Those of you who've let me teach you for your law school, part of your law school careers, I'm humbled and privileged that you are willing to trust part of your legal education to me. We're all, the faculty here, very proud of you. We expect great things from you. I know you won't let us down. Good luck. Best of luck to you in the future, and thank you very much.